Good morning, Mr. Pretorius. Good morning, everybody.
Morning, Chair.
Yes.
Morning, Chair.
Good morning, Mr. Agrizzi. We are starting with a matter relating to Mr. Agrizzi and Ms. Jabulile Elizabeth Sishuba, and then we will thereafter proceed with the evidence that we were hearing yesterday. Yes, Mr. Pretorius.
Chair, the purpose of this brief hearing this morning is to allow Mr. Agrizzi to put an apology on record in respect of evidence given in January last year. But because it's a public apology, it's necessary to place the words that Mr. Agrizzi would use in their context. And if I may take 5 minutes to do so.
Yes.
On the 24th of January 2019, Mr. Agrizzi testified and, amongst other things, gave testimony implicating Ms. Sishuba by saying that she had received money from BOSASA or one of its subsidiaries. A Rule 33 notice was issued to Ms. Sishuba, and she, consequent upon that, made an application requiring the allegation to be retracted, and if there was no retraction, she would apply to cross-examine Mr. Agrizzi. In response to that, and on affidavit, Mr. Agrizzi on the 8th of April 2019 retracted the allegation and apologized. A further affidavit was filed by Ms. Sishuba, which noted the apology, but raised the issue that the apology appeared to be somewhat qualified and proffered the wording of a different apology. There was a further response filed by Mr. Agrizzi on the 2nd of August, which confirmed the contents of his previous affidavit, and he stated, quote, "I take full responsibility for the error that occurred," unquote. The application by Ms. Sishuba came before you on the 3rd, came before you later in 2019 during August, and on the 3rd of September 2019, you, Chair, made a ruling saying that Ms. Sishuba's application was justified, but that no order was necessary to be made, and you noted that Mr. Agrizzi would apologize on record in an open hearing. If I may just quote from your ruling, Chair, you stated on the 3rd of September at page 44 of SEQ4, "I think it is enough that Mr. Agrizzi has said, 1, he made an error by suggesting that Ms. Sishuba had received bribes from BOSASA. 2, he said he takes full responsibility for that. 3, he said he apologizes to Ms. Sishuba for that. 4, he said he will repeat all of this when he comes before the Commission next time." In those circumstances, you said, Chair, it was unnecessary for you to make any positive order. Arising out of that background, Chair, Mr. Agrizzi is now here to place on record his apology. Mr. Agrizzi?
Chair, good morning again.
I'm sorry, perhaps you should be sworn so that
Yes,
the apology is on oath.
Sworn first. Please administer the oath or affirmation.
Please state your full names for the record.
Angelo Agrizzi.
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Yes, Mr.
Mr. Agrizzi, I understand you have prepared an apology and are ready to place it on record.
Yes.
Would you do so, please?
Chair, and Mrs. Sishuba and your counsel, I'm truly sorry. It was, as soon as it was brought to my attention right in the beginning that there was a confusion, and I confused the names, I already apologized. So there was it wasn't malice intended. I think it was rough, it was confusing, and everything happening. So I'm really sorry, and I don't want to belabor the point, but I think that I understand that it's done harm and damage. And as I apologized to Mrs. Shushuba this morning, I said to her sorry, and she accepted it. So I thank you for accepting my apology. I really do. I made an error, pure error, and I'm sorry. And I understand. In that's it's damaging to people, and I'm sorry. I really am.
Thank you. Thank you. I think that we are therefore done. Mr. Agrizzi has once again apologized to Mr. Shuba, has said that that was an error, and I think that's where it should end. Thank you. Are you ready that we release Mr. Agrizzi?
Thank you, Chair.
Yes. Thank you, Mr. Agrizzi. You are released. Thank you very much.
Chief Justice.
Thank you. I will adjourn for 5 minutes to allow for rearrangements so that we can proceed with the evidence for the day. Okay, we adjourn.
strikes and so on. You recall that?
I recall, Chairperson.
And one of the questions that you reflect on in your affidavit, Mr. Molefe, is how is it that, given all of these disruptions at PRASA, given all the scandal that racked PRASA, Mr. Montana survived? That's a matter you address in your affidavit. Will you outline to the chairperson what your view is as to how that came about?
Chairperson, I would like to place on record a minor correction regarding the point that was raised by counsel in respect of individuals or persons who could not be served with notices. I need to clarify the second part of it. Bashumi is actually not a person unless we're talking about juristic person. It was a company that was established by Mr. Matlangu and his colleagues at Satao, an investment company.
Yes. I took it that Mr. Soni was using persons to include a juristic person, but that's maybe because when I read the affidavit, I understood it to be a reference to a company. But of course, it may be that the point you make is that that company is registered in South Africa.
In South Africa.
Yes.
Chairperson, as I understand it, and the reason it could not be served is the Mr. Mshlangu is the sort of creator of the company, and the company could only be served through him. And you'll recall, Mr. Chairman, on Wednesday, I said it was a person and a company. And that's the association between Bashumi and Mr. Mshlangu.
But if it's registered in South Africa, it ought to have a registered address in South Africa.
That's what couldn't be found, Mr. Chairman.
Or that could not be found. Was a check made, or was there somebody who checked in the relevant company offices, registers, and found out? Because as long as it is registered in South Africa, it should have a registered office. And that registered office would need to have a physical address.
Yes. Chairperson, that was done by the section, but can I get clarity on that? And when we do get clarity, we'll place it on record.
Yes. So that needs to be checked, because there might be nobody there at the registered office, but as long as it remains the registered office of the company, then you can even serve. There are various ways of service. Even if there's nobody, you can serve.
Yes.
And if the owners of the company have decided not to make any arrangements as to how they receive correspondence and court processes that are sought to be served, then that may be their own problem.
Yes.
But we would need to be seen to have served at the registered office. And that would serve if Mr. Matlangu is, for example, the managing director, he could be served on the same address, I would think.
Yes. I will attend to that.
Well, thank you, Mr. Molefe, for bringing that clarification up. That, of course, raises the question of what do you do if indeed the one person, juristic person, is registered in South Africa and has an address in South Africa. But no attempt has been made to serve on that address.
I can say to you from what I have received from the administrative section of the Commission, Chairperson, that an attempt was in fact made. And what is recorded here is there are no contact details either for Mr. Mashlangu or Bashumi.
Yes, but the question is, was there an attempt made to serve on the registered address?
Chairperson, may I suggest the following process, Chairperson, that we make those inquiries as soon as we can, and if there are contact details, then we effect service now and just extend the period for the 3.3, the rights contained in 3.3. To apply from the time service has been effected.
Well, I don't particularly remember how serious the allegations are that relate to Mr. Mahlangu and Bushumi. But it's important that, if at all possible, all reasonable measures be taken to ensure that service is effected.
Yes.
And it doesn't necessarily mean that the Rule 33 notice has to be given to a person if there's nobody, and reasonable attempts have been made to get somebody, but at least that those attempts should be made, and then somebody should, if it's not a return of service from a sheriff, then somebody who made those attempts needs to depose to an affidavit setting out what attempts were made.
Yes.
The one option, of course, is that because those attempts are yet to be made to serve on the registered address of the company, which could be used for Mr. Mahlangu as well, one option is that Mr. Molefe's evidence would skip the part relating to Mr. Mahlangu and Bushumi until that has been done. It would just be, would have to apologize to Mr. Molefe that he would have to come back for what might not take long, but because it's necessary that attempts that were not made should be made. So that's, I think that probably is a safer route. Yes. Mr. Molefe, how do you feel about having to come back to deal with that later after these attempts have been made?
I'm happy with the guidance that I will have from the chair and council.
Thank you very much.
As you please, Chair. Mr. Molefe, I just want to return to the issue you reflect on in your affidavit, namely, how is it that Mr. Montana, with all the scandal surrounding him and PRASA, would survive from 2008 to 2015?
Chairperson, I indicate in my affidavit that I found it quite intriguing that despite the findings by the High Court in this land and the Public Protector in her reports about corrupt activities of Mr. Montana. He continued to go around with nobody really taking up those matters. The first point I make in an attempt to look at what might be the cause of that and the relationships between Mr. Montana and certain political offices is that during 1990s, late 1990s and early 2000s, Mr. Montana and a gentleman whose name features prominently throughout, and in particular in the Sifambo contract, Siaya relating to the Braamfontein depot, and several other services provided to PRASA, worked for the Department of Public Enterprise under Minister Jeff Radebe. Mr. Montana was the director in the office of the Minister Radebe. And Mr. Mackenzie was a director in the same department, different division, but reporting to the Department of Public Enterprise. The second point I make is that when Minister Radebe in 2004 was appointed Minister of Transport, Mr. Montana followed him, and when he got there, I think he ended up at the high position of Deputy Director General, which is a big jump from what he was at Public Enterprises. Around that period when Minister Radebe was the Minister of Transport, the government initiated an ambitious program of taxi recapitalization with a view to improving taxi services in South Africa, giving them vehicles which ostensibly were to assist in minimizing breakdowns and accidents that affected the passengers. When this program...
I must just confess that I never quite understood that, that program, but it's okay. I'm saying I must just confess that I never quite understood that program of recapitalization of taxis or whatever, but it's fine. Maybe I just never got somebody who could explain it properly.
Thank you very much, Chairperson.
But I must just ask Mr. Molefe, from here, do you hear me well? Because I did pick up yesterday.
I do.
You do, okay. Yesterday at some stage, I wasn't sure whether you could hear me well. Yeah.
There was a time when one question I couldn't hear.
Okay.
Except after it had been repeated. Well, it might also have been my mind being elsewhere at the time. I can't blame it on the Chairperson.
Okay, all right. You were continuing, and I interrupted you. You were saying there was this big program that of taxi recapitalization that the Department of Transport came up with.
When the taxi recapitalization program began, two things happened. Mr. Montana was given the responsibility to own that process. It means to be the one who directs the taxi recapitalization program. The second thing that happened was that Mr. Mackenzie decided to go into the private sector. He became private, business person. And what happens is that he then becomes one of those, perhaps even the key one, who gets a tender, ostensibly to provide transactional advisory services with regard to that tax recapitalization program. The third point we make, which I make, I keep saying we, like one of the witnesses previously. The third point I make is that a few months later, and as a result of the South African Railways Commuter Corporation, which was an offspring of what used to be a big organization that included Transnet and others, including South African Airways at the time. Now it had been created as a new organization. Minister Radebe then appointed, that organization changed its name to what is currently known as PRASA. That's SARCC, became PRASA. Then Minister Radebe appointed Mr. Montana. Firstly, he put him on the board whilst he was still in his office. Later, he appointed him the group CEO of that organization. Now we're looking at two individuals, Mabunda and Montana. When Mr. Montana moves to SARCC and what is now known as PRASA, Mr. Mabunda emerges again as a very important service provider to PRASA. He provided a whole range of what they called transactional advisory services. He was advising on the major signaling rollout program, which I referred to earlier on in my evidence as one that had to do with the establishment of this nerve center in Braamfontein by Siemens, and the rollout in KwaZulu-Natal under the auspices of Bombardier Transport Signaling Division. The third one was Thales Africa with their black partners in the Western Cape. So Mr. Mabunda then was brought in to be the transactional advisor to all these important projects.
Sorry, Mr. Molefe, and I know you want, I just want to work out.
Raise your voice, Mr. Soni, please.
Sorry, Chairperson. What were Mr. Mabunda's qualifications to be given these massive contracts?
Chairperson, I wouldn't want to speculate about that. I don't know.
Yes.
But when we did other investigations, say, for example, with regard to Swifambo and so on, he didn't appear to know much or anything about leasing of locomotives or manufacturing or so on. But I may say that, by the way, in the evidence that emerged as a result of the investigations conducted on Swifambo, it appeared that he had bought a company, a micro-lending company, which micro-lending company was then transformed into Sefambo. I have no evidence of any other qualifications that he would have had to justify him being given all these contracts, save that he had worked in this very important office that had these big programs to roll out.
Just on that score, you say that he also headed CIR Engineering Consultancy.
Yes, he did so, Chairperson.
Do you know if he had any engineering qualifications?
I have not personally established whether he had engineering qualifications. That notwithstanding, of course, maybe he did have, but he got all these important programs with critical engineering requirements.
And you know that the evidence will be that CIR, the CIR companies earned more than R1 billion from PRASA, or were paid more than R1 billion from PRASA. I'm just placing that on record.
Well, at this stage, I wouldn't say I know that evidence would be led in that regard because I haven't seen anybody's statement saying that. My statement does say he was paid approximately, CIA was paid approximately 900 million.
Yes.
Sorry,
carry on. Now, you also mentioned Mr. Daniel Mtimkulu in paragraph 51 of your affidavit. What role did he play in the formulation of these policies or the award of these contracts?
Mr. Daniel Mtimkulu, as somebody designated chief engineer at the time at PRASA, although evidence later demonstrated that he had nothing that would have brought him anywhere near being called chief engineer, was responsible for most of these programs. He worked very closely with Mr. Mackenzie. He is the kind of a person who would have made submissions to the group CEO on approvals of a range of these projects. I'll be guided by counsel. I can go on and deal with others where he's got a role because now I don't know how far to go. But maybe I should leave that for when we come to some of those points.
We will, and we will deal with what the Supreme Court of Appeal especially said about Mr. Mtimkulu. So I want to return to that because it is something that is important for the Commission, for one, but also something that has to be set out in public.
Maybe what might not be a bad idea, Mr. Molefe, is that you make a note of some of the issues that you believe are important, and at the end of Mr. Soni's questions, if I can give you a chance, if there are other matters that you believe are important that you should tell me, then you can deal with those if you believe that they are important. Yeah.
I'm happy to do so.
Yes. Okay.
Now, thereafter, just coming to Mr. Mtimkulu, you in fact refer to the judgments of the High Court of the High Court and the Supreme Court of Appeal in the Swafambo matter and the comments they made about Mtimkulu. You say that at paragraph 55 of your affidavit.
I do, Chairperson.
Now, can we then deal with the Swifambo matter? And Mr. Molefe, your affidavit refers to the judgment mainly of the Supreme Court of Appeal, and we will refer specifically to certain paragraphs of the judgment. But before we do that, can you tell the chairperson what the Swifambo contract entailed?
Chairperson, the Swifambo contract entailed initially it was intended to be, and that is what was articulated in the RFP, the leasing of locomotives, which would be used for what was called the mainline passenger services, but also used in routes in the metro areas where, of course, there were a lot of failures of old locomotives, which we said were not recapitalized for 40 years. So that was supposed to be. But of course, in the course of the process of procurement, I suppose something that typifies how procurement processes were manipulated. Suddenly, Swifambo was allowed to offer a proposal on the manufacturing of locomotives, which was not part of the RFP right at the beginning. So the process went on. There were specifications of what would be needed by PRASA, because PRASA was going to operate on the rail tracks and signaling systems that had been designed by, at the time when Transnet was still that big organization with everyone inside. And what was to be leased or procured needed to comply with the rail safety regulators' requirements. So they would have had to be approved by the rail safety regulator. But they also needed to comply with the rail network of Transnet.
Now, you have intimate knowledge of the Swifambo matter because you made the affidavits in support of PRASA's application to review and set aside those awards. Am I correct?
That is correct.
Now, just again as a general proposition, without going into details, what were the points that you took, when I say you, I'm talking about PRASA, took in asking the court to review and set aside the award of the contract to Swifambo?
The investigation, Chairperson, that we conducted demonstrated conclusively that that procurement process was flawed, was corrupt, or let me say corrupted, that Swifambo itself, notwithstanding the fact that it did not meet the requirement set out in the RFP, this being amongst others, the need for them to have a track record in rail business, either be leasing or manufacturing. They needed a track record. Secondly, they needed to demonstrate that they had the skills necessary to carry out a program of that size and as complex as it was. The third point was that they needed to have, and I think it would be an element that includes that capacity, sufficient qualified people to carry out the program. Fourthly, it was a requirement that a bond deposit of 10% of the value of the contract be paid up front. They also needed to demonstrate that they would be able to implement the local content requirement, which is often included in the triple PFA. Now, in respect of all of those matters, Sifambo did not qualify. I needed to have said also earlier on when I said that there was a need to comply with the rail safety network, the rail systems network in South Africa, that in fact, initially, what should have been procured by PRASA would have been in the context of Europe and Spain would have been Euro 3000. And Euro 3000 is a model of a locomotive that would have complied with in all respect with the requirement of South Africa, including Israel, narrow gauge, the height of the electric pylons, the pantograph on top of the locomotives, and so on. But in the end, what was procured was what was known as Euro 4000. It was so because the company, Vosloo, which at this stage was not bidding to supply these locomotives, was also advising PRASA on what it needed. And that company in Europe, in Spain and Barcelona, had already discontinued the production line for Euro 3000, and they started the production line for Euro 4000. It would appear that they did so because there was no longer traction for that product where they were selling their locomotives. So they then influenced PRASA to buy what more or less was from the shelf, no longer according to the specifications set in the RFP. And interestingly enough, I don't want to go into the details of what happened in court, but the evidence that emerged also was that, in fact, the company that became the subcontractor of Sifambo, but only after the contract was concluded with Sifambo, which had nothing, no capacity to provide locomotives, in their own report indicated that in fact they were in trouble. So PRASA's contract was the biggest ever and a lifesaver for Vosloo. I do need to say that I was asked about Mr. Daniel Mtimkulu earlier on. Daniel Mtimkulu was pretty central to the design of the specifications. He had interacted very closely with Vosloo. He was the one invited by Vosloo to to persuade the company PRASA to go along with Euro 4000, which later was baptized in South Africa to Afro 4000.
That's the background, and that's what you had set out in your affidavit in support of the review application. Would I be correct?
That is so. I need to hasten to say, Council, that Chairperson, that I had no occasion to refresh my memory, but by reading the affidavits, if there are minor differences, really, I don't think that'd be material. I think what I've presented is the essence of the message.
And I think what you have presented seems to be very much in line with the judgments that were given.
So can I then say the first issue that I want to deal with is what was the outcome when the matter went to the Gauteng local division in Johannesburg, the outcome of the review application?
Chairperson, when the matter went to the Gauteng High Court, our application, firstly, let me say, was to have the contract declared irregular and to have it set aside as being unlawful. That is what the court granted. It declared in a very scathing judgment that contract was corrupted from the beginning. It was irregular, it was unlawful, and fell to be set aside.
Okay. We'll deal with the bases on which that was done. The matter then went to the SCA.
There is just one point I need to make. I hope Council does not get irritated with me.
No.
Because I don't know if we're going to get the opportunity to get to it.
Yes.
We come down showing the relationship between Mr. Montana and Mabunda. We didn't deal more with his relationship with Tumkuru, but it was there because he appointed him this chief engineer and he was reporting to him.
Yes.
In that case before the High Court of Gauteng, Mr. Montana applied to become the friend of the court, but basically saying that there is evidence that PRASA should be placing before the court. It is not. One would have expected that you would say to PRASA, I worked in this company, there are these other matters that you seem to have left out. He did not. But what emerged in that his application was that fundamentally he wanted to defend the Sifambo contract.
Oh, okay.
So can I then, just on that point, Mr. Molefe, ask you to look at the judgments bundle, please?
Just tell him what's written on the spine.
Is that the... should be my statement.
Also for the record, just say what is written on the spine of the bundle.
There's court applications,
Chairperson, it will be SS2 judgments. It will be bundle A, SS2 judgments for you, Mr. Chairperson.
So it's bundle A.
Bundle A and SS2.
And the judgment is?
It's the first
SS2.
Judgment in that.
Okay. So that's what page of the bundle is it?
Page 3, Mr. Chairperson.
Well, I think
page 3 of the record of that bundle.
Are your numbers not sequential here? Oh, they are not. Okay. It's page 1 of the judgment. That is the judgment of Judge Francis.
And then it'll be the second page of that judgment.
It's supposed to be, I think that's just confusing. But are you able to find it under SS2, Mr. Molefe? You have found it?
I have found it,
Yeah,
Chairperson.
okay.
And for the record, Mr. Chairperson, this would appear at SS2, page 3. Could you read paragraph 3 of what Judge Francis said into the record, Mr. Molefe?
Are we on page 3?
What paragraph
paragraph
number,
3.
Mr. Soni? Do you want him
Page
to
2
read?
of the judgment, but page 3 of the bundle of SS3. Oh, sorry, SS2.
No, I think tell him the paragraph number of the judgment that you want him to read.
Paragraph 3, Mr. Molefe.
Yeah,
I
I
have
think
it in front
you
of
may
me,
have said page 3.
That is what confused me.
Okay.
Initially, we said page 3. That was.
Yeah, I think he said
couldn't
page
see
3.
paragraph
Okay,
3 on
paragraph
page
3. You want him to read that part, that paragraph?
Yes.
Okay.
The paragraph reads as follows, Chairperson. At the commencement of the proceedings, I had an application brought by Lucky Montana, in brackets Montana, who used to be the Group Chief Executive Officer, in bracket GCEO, close brackets, of PRASA, to be admitted as a friend of the court. That application was dismissed with cost, and reasons were provided in a separate judgment.
So that is the point you
The
wanted to
point
make.
I made earlier.
Mr. Chairperson, that judgment is available, the application papers are available, but we would make them available and have them as part of the record if you wish, but having considered them as a whole, we
There's
don't think
nothing
it adds to what we
anything.
are concerned with. Mr.
Okay.
Chairperson.
Okay.
Then, Mr. Molefe, can I ask you to look at the second judgment there, which appears at page 63 of SS2.
Assuming that the dividers have the same colors, it's under 2 of the green dividers for me.
Yeah.
I think Mr. Soni,
But you don't have 60. What is this page?
in this bundle, the pagination is still not how it should be. For everything that's in the same bundle, there should be a complete pagination from page 1 up to the end, so that when you say bundle A, you just say page so and so, without having to look at the page number of the particular document. So maybe at some stage that can be sorted out, and for all others to follow.
Yes.
Okay.
Are you there, Mr. Molefe? Have you located the judgment?
That's the judgment of the Supreme Court of
It
Appeal.
would seem in the document it is recorded as page 64. I have.
Yes. You see, it
found
says Supreme Court of Appeal judgment.
That is correct, Chairperson.
Now, I want to refer you to some of the paragraphs of the judgment. And can I start with paragraph 4 of that judgment?
Of course, Mr. Soni, Mr. Molefe can just make the important points without reading, unless there is something significant in a particular paragraph, then it should be read.
Now, you were making the point that it was Mr. Mtumkulu who drafted the specs for this. What does the SCA say in that paragraph regarding the role of Mr. Mtimkulu?
The SCA chairperson, and I'm paraphrasing, following what the chairperson has said, held that, noted that Mr. Mtimkulu, as I said, was the one who drafted the memorandum and made submission. And he recommended that PRASA procures, at that time, 100 locomotives at the cost of 5 billion rand, and correctly stating that because the fleet that PRASA had was outdated.
Yes, and then if you turn to paragraph 7.
I can say, Mr. Soni, also that because this is a judgment as opposed to any other document, it's quite fine to just highlight, even if you highlight,
Yes.
to say, in this paragraph, this is the conclusion reached by the Supreme Court of Appeal. In that paragraph, just highlight the conclusions. And then if Mr. Molefe wishes to add any perspective in regard to any conclusion of the court, then he can do so.
Mr. Chairperson, in a sense, Mr. Molefe's affidavit itself does exactly that, and maybe it would be better just to deal with the, because he actually sets out which paragraph he's speaking to.
Yes.
And perhaps I should just leave him on his affidavit.
If he has captured, and I think he has in his affidavit, we don't need to go to the judgment unless there is a paragraph where there is something special about how it's phrased or anything like that. If we just capture what were the important findings or conclusions reached by the Supreme Court of Appeal, that should be enough.
Yes. And I have checked them over again, Mr. Chairperson. They coincide.
Yeah, no, that's fine. As I say, unless Mr. Molefe has some important perspective that he wants to highlight in regard to any particular finding.
So, Mr. Molefe, to place matters on record, can I ask you to start looking at your affidavit from paragraph 61 and just indicate what were the important points made by the Supreme Court as you captured in your affidavit. And you don't have to read everything there. You could just say at paragraph 6, this is what they dealt with, this is what they dealt with. But it's then part of the record of the evidence before the Commission, Mr. Molefe. Are you with me at paragraph 61?
I am, Chairperson. The paragraph 61, Chairperson, confirms the statement I made earlier on that Mr. Mtimkulu in July 2011 submitted to Mr. Montana a recommendation in respect of, in which he was asking approval for procurement of 100 locomotives over a period of 6 years. But an RFP was then published in November of the same year. The RFP recommended, was calling for procurement of 88 locomotives. My recollection is that at the end of that process, in the final analysis, only 70 locomotives were ordered.
But for this, and what was the price? Was there going to be a change in price?
The prices would change, and the price changed then from 5 billion rand to 3.4 billion.
When I read the Supreme Court of Appeal judgment, I didn't pick up anything that may have been placed before court that explained how the number of locomotives jumped from 88 to 100. I may have missed it. Do you recall if there was any explanation as to how the number jumped from 88 to 100?
Chairperson, attempting to deal with that question, I must say that my experience as a board, were interrogating these matters, we found that no hedging or no correct foreign currency hedging was effected, built into the procurement price. To the extent that it was done, it was, for example, one that put exchange rates of rand to euro at 10 rands 40 cents per euro. By the time this procurement happened, the exchange rate had changed. So the hedging was not protecting PRASA against the escalation. So as the euro became stronger and the rand weaker, the prices went up. And when the price went up, the budget being what it was for 88 locomotives, PRASA could no longer, well, let me start off, being 400 locomotives, could not afford to pay for 100 locomotives because it would have then meant that it would need to put more money to meet this escalation of the euro. So that is what then caused management to constantly reduce the numbers to try and deal with something that they believe would be manageable.
I may have misunderstood something. I thought you said the RFP had contemplated 88 locomotives, but ultimately what was ordered was 100. And I was asking about that jump, but what you have just told me seems to suggest that 100 may have been contemplated, but because of there having been no hedging, then a lesser number of locomotives had to be obtained.
I think I was mistaken. Let me try and take it in a chronological order to clarify matters.
Yes.
A memorandum for procurement of 100 locomotives is submitted to Mr. Montana by Mr. Mtimkulu in July 2011. He says, let's buy 100 locomotives.
Yes, yes.
However, when the RFP is issued, PRASA says, no, we'll procure 88 locomotives. I have no recollection of any motivation why Mr. Mtimkulu's request for 100 locomotives was not accepted as was.
Okay.
Now, so the order is then the RFP envisages 88 locomotives. But because of the passage of time, and at that time, the price tag was 10 euros and 40 cents. But as time lapsed, the euro was escalating, getting stronger, the rand weaker. Even the 88 locomotives could no longer be affordable on the budget that was set aside at that time. So management then reduced the numbers again.
Yes.
I think, to a lesser
Yes.
than 88 locomotives.
Yes, okay. Okay, now I understand. I think I may have got the 88 and 100 wrong. From what you say, the 100 came from the memorandum from Mr. Mtimkulu to Mr. Montana, but at the time of the RFP, 88 was the number that was put in the RFP.
That is correct.
Yes, okay, thank you.
Mr. Chairperson, just again, if I could put on my lawyer's hat, one of the points that was made is there wasn't a need analysis for how many exactly were required. So that also, in a sense, tainted the procurement process, because when one procures for that amount of money, one needs to say, well, we need 20, or we need 50, or we need 100. And if you read both the judgment of Justice Francis and Justice Lewis, you will see, Mr. Chairperson, that is part of the theme that emerges, aside from the issue that Mr. Molefe
Yes,
raised.
okay. No, thank you.
Yes, and then, Mr. Molefe, you had finished now with what the specifications were. At paragraph 62, you detail what the SCA said about Mr. Mtimkulu. Could you place that on record?
Yes, Chairperson, the court held, the SCA held that Mr. Mtimkulu had no expertise on the subject that he was given responsibility for. But it also noted that he had been if you like it, just elevated and promoted to that position of chief engineer. And
By whom? By whom?
By Mr. Montana, and the court noted that his rise was meteoric. I don't know good English, but I think it means that very rapid, very fast, and concomitantly. What together with this rise was also the rise in his salary increase.
And as regards his qualifications, what did the SCA say?
The SCA had established, held that he didn't have the qualifications. And it arrived at that conclusion, Chairperson, because in various ways, Mr. Mtimkulu had lied about his qualifications. He claimed that he had a bachelor degree in technical, in engineering, something like that. And he also later argued that he had a PhD, a doctorate, from a German university. And in one meeting where I sat with him, he produced a letter because we said, show us the award that you qualify. You have this qualification. And he produced a letter. I said, no. The award of a doctorate is not done in this way. Why is it that this appears to be just a letter that you would just show to people, where we want to see the real award by the university? He did not have that. In the end, of course, it was established that he didn't even have the technical diploma that he said he had.
Now, one of the matters that the SCA deals with in paragraph 7 is...
Well, maybe, Chairperson, I should say that in order for Mr. Mtimkulu to get where he got to, he lied at different times. At one point, he lied to the board and Mr. Montana that a company called DB Schenke in Germany had offered him a job, and he was going to leave the country to go and work in Germany. And Mr. Montana, believing that Mr. Mtimkulu is an asset to PRASA, said, no, don't go. We will pay you what that company was going to pay you. And so that's how he found his way. I just wanted to put that on record as well.
Was there such an offer?
It was a fake letter. The investigations proved that there had never been such an offer. The company that he said made him an offer didn't even know him.
And as regards his qualification, just read the last sentence of paragraph 62 of your affidavit. What did the SCA say about his qualifications?
The SCA categorically says, in fact, he had no qualification at all.
Tell me, did you ever, at any stage at PRASA, get to know whether in his personnel file that PRASA is supposed to have kept, whether there were documents that purported to be degree certificates, diploma certificates that he may have used to mislead whoever appointed him or promoted him to various positions? Or did he just say, I've got this qualification and that was accepted? Is that something you ever got to know?
My recollection is that he produced letters from various institutions. And I think in the case of the Val Technical College, which is here in the south of Gauteng province, he produced what purported to be a diploma. The institution rejected that and said that it was a fake diploma.
Thank you.
Now, in regard to...
Mr. Soni, you must help to keep your eye on time. We need to take the tea adjournment. We normally take it at 11:15. Let's take the tea adjournment. It's now 22 minutes past. We will resume at 22:12. We adjourn. Okay, let's proceed.
As you please, Mr. Chairperson. Mr. Molefe, you were saying that Mr. Mkulu, according to the SCA found Mr. Mkulu had no qualifications. What did they say about, and we've dealt with this in your evidence, but what was their finding in regard to the specifications drawn up by Mr. Mkulu?
The first point that the court makes is that Mr. Mkulu contravened the procurement policy of PRASA, which means supply chain management process, that he actually used the specifications provided to him by Vosloo. He makes that what PRASA procured to suit what Vosloo required. And Vosloo, as I earlier indicated in my evidence, had in May of 2011 given advice to PRASA on what its requirement should be.
And what did it, sorry, you.
No, it's okay.
What did it say about Mr. Mkulu's, how Mr. Mkulu determined those specifications? You refer to it in your affidavit when you say the SCA agreed at paragraph 63.
Well, basically our finding, and it was in our investigations as well, that Mr. Mkulu tailored the specifications to be in line with what the company Vosloo required, and it had no relevance to the needs of PRASA. There was no strategic procurement planning. There was no needs analysis, as we said earlier on, but they proceeded then to procure this locomotive to benefit both Sifambo and Vosloo. And clearly, therefore, and that is what the court states, is that the tender process was corrupt.
Now, in regard to Mr. Mkulu's actions, what did Francis J. say regarding his state of mind?
The Honorable Judge concluded that Mr. Mkulu conducted himself in a dishonest manner, and that even Sifambo, which is a company that he awarded the tender to, did not deny that conclusion.
And in regard to Mr. Montana's role in this practice of Mr. Mkulu, what did the SCA say?
The SCA concluded that Mr. Montana's conduct was he was party to the conduct of Mkulu.
And as regards the entire process of Sifambo bidding but relying on Vosloo, what did both Francis J. and the SCA find?
The SCA found that Sifambo was actually fronting for Vosloo because all that it had said to PRASA it could not do. But it is also so, Chairperson, because at the time when the award was granted, they did not even have the subcontractor with their technical partner. They didn't have that. The envisaged technical partner who was to be Vosloo. And I do need to say that in one meeting of myself and directors of PRASA, where Sefambo had come to ask for the board to support and approve, I think, an addendum. There had been, submitting various addenda because things were changing for them, wanting more money and so on. I think this one was the third addendum. I had occasion in that meeting to ask them if at the time of procurement they already had Vosloo as their partner, and they said, no, we wanted first the tender to be awarded, and after that we were going to tailor the subcontract we signed with Vosloo in line with what the award says, the contract that we signed with PRASA. Now, that's putting the cart before the horse, because the award should not have been approved without demonstration of this capacity and the fact that there would have been a subcontractor already with a subcontract concluded. There was no subcontract concluded. That is my addition, Chairperson, on this part. I'm not quoting the judgment.
Yeah. You said a few minutes ago that the Supreme Court of Appeal, I think that's what you said, you might have been talking about the High Court judgment, that they said Mr. Montana was party to Mr. Mtimkulu's conduct. Did I understand that?
That is
correctly?
so.
Yes. Now, you have said, and I remember that it's in the judgment, that the Supreme Court of Appeal did say that Mr. Mtimkulu conducted himself in a dishonest manner. Did you have any understanding whether the Supreme Court of Appeal saying Mr. Montana was party to Mr. Mtimkulu's conduct, whether it sought to say he was party to the dishonest conduct as well, or it may have simply meant that he was party to certain activities, but not necessarily the dishonest part? So I'm just looking for your own understanding.
I would be careful not to misconstrue the judgment, but I understand that that to the judgment, the statement in the judgment to mean that Mr. Montana acquiesced in the misconduct, corrupt conduct of corrupt conduct of Mr. Mtimkulu. We have tabled a number of things that have happened. There are also some strange things that, and I'm just throwing this in, it has nothing to do with the judgment, that Mr. Montana did. Before my board was appointed at PRASA, it had happened that Mr. Montana's contract had expired and had been renewed. Which is one of the things he said to me when we had one-on-one, that, look, I wanted to leave and they persuaded me not to leave, and I agreed to the extension of this contract. That is when he was trying to convince me that I should accept that when his contract ends, he would not stay. But relating to this question, what I want to raise, Chairperson, is that in the course of our investigations, and it is a document I'll submit to the court, we established that similar to the conduct of Mtimkuru, Mr. Montana, when he wanted a rise in salary and extension of his contract, submitted a fake offer of employment, a letter that was given by a company called Gypsum Fertilizers. Our investigations established that that company had
never made an offer to him.
Had not, well, the offer that they were making is the kind of offer of a business that does not exist as a solid business. It's you could call a newly registered company. It didn't even have offices. The registered address was a house in Bedford View. And I think the evidence before the High Court would demonstrate that. So what I'm saying that the dishonesty that is being spoken of is not only about Mtimkulu. You also had these instances where the chief of administrative functions of the business was doing similar things.
Okay, thank you.
Finally, Mr. Molefe, at paragraph 66, you set out what the SCA said about Mr. Montana. Do you read that into the record, please?
Chairperson, the paragraph of the SCA judgment reads in this manner as follows. The SCA, he controlled PRASA and its staff, was obstructive and attempted to cover up his role in various corrupt transactions, including the award of the tender of Swifambo. Of course, the public protector had experienced a similar obstruction in her investigation. We referred to it earlier on in my evidence, and it is detailed also in the public protector's report.
It perhaps would be an ideal opportunity now to look at the public, what you say the public protector's report is, and you deal with that.
Well, before you do that, Mr. Soni, well, maybe allied to the question that I put to Mr. Molefe about his understanding of the Supreme Court of Appeal's judgment in relation to Mr. Montana's conduct in relation with special reference to Mr. Mtimkulu's conduct. I see that the quotation from the judgment in paragraph 66 of Mr. Molefe's affidavit does seem to suggest, and I want to put the question to you because you would have applied your mind maybe better than I have in preparation for this, whether that's your understanding. It seems where there the Supreme Court of Appeal is quoted to have said Mr. Montana controlled PRASA and its staff, was obstructive, and attempted to cover up his role in various corrupt transactions, including the award of the tender to Swifambo. Now, that seems to suggest that he had a role in various corrupt transactions, but he sought to cover that. Is that your understanding?
It is absolutely.
Yes.
So,
Yes.
Mr. Chairperson, if I could go back to the question, and maybe I should have seen that,
Yes.
that they are related, that although it didn't expressly say so when it referred to Mr. Montana had a role in Mr. Mtimkulu's contract, the passage that has been read at paragraph 34 makes that quite clear.
Yes, okay.
That's how I understand.
Yes, okay, thank you. you are ready to proceed to the
proceed
public
with
protector's
the
report.
public, because it leads directly
Yes,
into it.
no, that's fine. That's fine.
Now, Mr. Molefe, yesterday we were talking about,
I'm sorry, is my understanding correct that nobody has ever challenged that report in court?
I was going to come to that, Mr. Chairperson. Mr. Montana, in 2015, filed an application to review the Public Protector's report. But it is a matter I want to address through Mr. Molefe,
Yes. Okay.
because that is of utmost significance, and what I will, through Mr. Molefe, point out is, in a sense,
The challenge was not pursued.
well, it is there,
But,
5 years later,
yeah,
we have the Public Protector's report, and we know what the Constitutional Court has said
yes,
about the status of her reports.
Yes, yes.
And you file a review application, which PAJA says you must file within 180 days, and 5 years later you don't bring it to fruition. But that's the point I want to make through evidence through Mr. Molefe.
no, that's fine. But what also should be done is somebody should inspect the court file and see what steps have been taken by whom since the launching of the applications, or whether it was simply launched and no further steps were taken, or whether some further steps were taken, but there's been a problem of getting a date which, on my knowledge of the Gauteng division, would be unlikely that somebody who may have been ready to have their date, have done everything they're supposed to do, that they would not have been given a date for 5 years or so. But somebody needs to go and check,
Indeed.
and maybe it would be useful to know what the state of affairs is, whether there are any further steps that Mr. Montana has taken to try and have that review application adjudicated.
Mr. Chairperson, may I just point out, at the end of this, when we make submissions to you at whatever stage, one of the points I will be taking is that the High Court has said that a review is preempted if it's not pursued, well, firstly, if it's not instituted within a reasonable time, and there are at least 2 cases which we will refer to, which says if you haven't prosecuted your review, so you may have instituted it, but you left it lying in court, the review is like an appeal. Then your right to review has been preempted. But that doesn't detract from what you have said.
Yes, because it would just be important to know if there are any steps, there are any legitimate challenges in pursuing it. Because if there are no legitimate challenges in pursuing it and having it set down, then one has got to look at what one makes of that.
Yes, yes. And as regards the status of that, Mr. Chairperson, may I refer to 2 passages from the Public Protector's report, which are not in Mr. Molefe's affidavit, but which are relevant to the issues you have raised, Mr. Chairperson. Mr. Molefe, Mr. Chairperson, perhaps for orientation, the Public Protector's report is in bundle C, I think, in your set of files. I've indicated to.
What is it?
He will wait for you to give the page, so before he gives it to me.
The page number of the report itself, Mr. Chairperson, is page 20.
I've got page 20.
Oh, sorry, Mr. Chairperson. It's page 22.
Okay.
Have you got it, Mr. Mr. Molefe?
I've got it, yes.
May I ask you to look at paragraph Roman 22? And that's just before the first big number on page 22.
Yes. Is it the one saying after careful, after
Yes,
a careful
sorry,
examination?
yes, paragraph 21. Sorry, not paragraph 22. So it's XX1. Would you please read that into record, Mr. Molefe?
The paragraph reads as follows, Chairperson. What is encouraging is that both Mr. Montana and the board have welcomed the provisional report, which did not differ vastly from this final report, and committed themselves to implementing the remedial actions once the report is made final. For this, I am grateful, and as such, conduct is in line with the constitutional ideal regarding the relationship between the public protector and organs of state, as envisaged in Section 181 of the Constitution.
Yes.
Section 181 enjoins organs of state to assist and to protect the public protector and other institutions supporting constitutional democracy to ensure their effectiveness, among other things.
May I then also ask you to turn to page 64 and paragraph 3.6.
Is that page 64 at the bottom?
At the bottom, sorry, yes, Mr. Chairman. If you could read that. You could read that paragraph into the record, Mr.
Which
Molefe.
paragraph is it?
Paragraph 3.6.
On mine, that should be at page
on page
65 and not 64.
Oh,
I thought you said 64.
it is 64 on mine. I'm sorry, Mr. Chairman.
Yeah, Mr. Molefe, is it 64 or 5 with you? Pay paragraph 3.6.
Is it paragraph 3.5?
3.6.
3.6.
Then 3.6 is on page 65 on my,
Yes.
file, in my file.
Yes. So as you refer him to pages, you need to remember
need
that
to confirm, yes.
you are one page behind.
Yes.
Yeah.
So would you read paragraph 3.6 on page 65 of the Public Protector's report into the record, Ms. Molefe?
Mr. Montana's response to the provisional findings was, however, deeply encouraging. He said in part, and we quote, "We confirm that PRASA welcomes the provisional report and the remedial actions recommended by the Public Protector. PRASA views the remedial actions concerned as an essential tool to assist in improving its internal administrative and financial controls. PRASA believes that the remedial actions will in future strengthen its governance framework, operations, and internal controls in ensuring that PRASA is safeguarded against irregular or unlawful conduct within its organization," close quote.
Ms. Molefe, I just place that on record and then ask you to comment on the following. Mr. Montana has filed an application to review the Public Protector's report.
Of course, A lot of people say a litigant files a review application to review. It's the court that reviews. to have the report reviewed and set aside by the court. Yeah. No, but that's just a technical thing.
No, but an important one.
Yes.
I'm just placing on record that to the extent that that review has any substance, the public protector's report will have to be considered in the light of the fact that there is that review. You understand?
I do understand, Chairperson. But in the light of what we have read in the public protector's report, ascribed to the response of Mr. Montana and the Board of Control, the old Board of Control, because it was not my board that responded. I think Mr. Montana has got a very difficult task because he first have to get what he responded to the public protector on out of the way to justify in reviewing it, because he's accepted it. Now it's difficult. I think he's got a difficulty, but maybe, well, lawyers know how to go around those things. But as a lay person, I think he's got a very serious difficulty.
So let's start with the findings that you highlight in your affidavit, and let's start with what you say at paragraph 68.
We're back in the bundle that has Mr. Molefe's affidavit now.
Oh, sorry, Mr. Chairperson. It's SS6.
Yeah, I've got it in front of me. Okay, we had gone beyond. Yes, okay, all right.
Sorry, Mr.
I think you might need to repeat your question.
Yes. In paragraph 68, you refer to, or you highlight one of the findings made in relation to the tender for two train stations valued at 1.95 billion rand.
I do so, Chairperson, and perhaps to provide a little context. The context is that at a certain point and before 2010, South Africa was awarded the status of hosting the
Soccer World Cup.
There's firstly there was the One Africa World Cup for Africa, and then later the Soccer World Cup that was coming in 2010. And PRASA, being an organization responsible for transporting many ordinary people, became part of that process by it had to improve the stations, do maintenance, and allow for access to those stations by those who would be wanting to attend the World Cup. So therefore, this contract was then issued, as I understand it, and the contract entails doing work. We refer to 2 train stations and was later extended to 7 stations. But this is also because it would seem like management, and perhaps Mr. Montana at the head, Mr. Montana himself, that they didn't think that when you have issued a contract, you can't, in the course of execution of that contract, willy-nilly change the scope to put more work, scope of work, and more costs to the contract. And this is what the public protector found.
Do you know who the contractor was in this matter?
The contractor in this matter was Siangena, which the company we referred to earlier on in my evidence.
Mr. Chairperson, may I, for your benefit especially, that appears at 359 of the Public Protector's report, at page 359.
Okay.
All those details set out in paragraph 68.
Okay, thank you.
Then, Mr. Molefe, may I ask you to set out what you say in paragraph 69 of your affidavit, which is SS6, in relation to the way Mr. Montana ran PRASA, or provide her with information.
The public protector found that Mr. Montana had approached her or the institution to say that is finding it difficult to get information from PRASA. With this being a main, I think the approach here is not correct. Let me go to the actual thing.
You can
I
read
think
it
the
if it's
prefacing is
necessary.
confusing.
You can read it if
The
it's
prefacing is confusing.
Yes.
The public protector says it was difficult to get information from PRASA. With this being the main causal factor for the delay in the finalization of the investigations and the report, the investigations that had started in 2012. The public protector says promises for documents were made, but they were not kept. Requests for assistance from the board also yielded nothing, and I must state here that it was the old board, not the board that I was chairman of. So source documents could not be made available. Now, just an ad-libbing of some kind. The contract of Siangena was continuing at that time. It couldn't be true that PRASA did not know where to find the source document of a contract that is continuing and for which they were continuing to pay. But that's what they said. But the public protector also finds that Mr. Montana boasted that, you see, they went and complained about me. Now they can't produce documents by way of evidence, and request the public protector to find in his favor, because he believes that those accusing him don't have, the accusations were baseless. Now, the company withholds documents which would disprove what the complainants say, if indeed they were wrong, but the company does not release them. And Mr. Montana, according to the public protector, boasts, says, look, I'm innocent, find in my favor.
Sorry, can I just deal with that issue with a few questions? As far as PRASA status in our constitutional dispensation go, what would PRASA be? Would it be a private body, an organ of state?
Earlier on in my affidavit, Chairperson, I state that PRASA is an organ of state. To that extent, PRASA is obliged to comply with the legal and constitutional framework of South Africa. In the earlier discussion in the course of this evidence, with the public protector, when she expresses her appreciation for Mr. Montana and the board of that time, saying that they welcome the report and the remedial actions required, and that in their view it would assist to improve the governance in the organization. Clearly means that they understood that they needed to support the work of the public protector. They were actually obliged to do so.
Mr. Molefe, before we go on to the next matter raised in your affidavit, may I ask you to please again turn to page 20 of the Public Protector's report now. If it may well be 21 in your copy.
Just mention again for the record the bundle.
It's bundle C.
It's bundle C, but I don't know whether that your own one is also marked bundle C. It should be, but you seemed not to be sure earlier on.
It's not, mine is not, ours has been marked differently, Mr. Chairperson.
Oh, but they need to be marked in the same way so that we are all on the same page. So when you need to tell me and the witness what bundle you are sure that it would be the correct bundle that we have. But it's bundle C on mine. Okay, and you said page 20.
It's either page 20
you are one
or
page
21.
behind.
I'm one page behind. So it's 20 on mine and
So
probably
to 21
on
with,
yours.
yeah. Okay, it should be 21 with your bundle,
Yes.
Mr. Molefe.
And it's paragraph Roman 18 XV111.
No, that's not on page 21. That is on page 20.
Oh,
On mine. Mr. Molefe, is it on page 20?
Mine is also on page 20, yes.
so
Yes.
this is where ours coincide.
Yes, no, but I think it's important that all your bundles, all your documents should be marked, paginated exactly the same
Exactly,
as ours, and they should be marked exactly the same so that we don't have this problem.
Yes.
Okay, all right. Page 20, Roman figure 18. Yes.
You please, so remember you were talking about Mr. Montana boasting that they couldn't produce, the complainants couldn't produce documents. Just like you to read paragraph 18 where the public protector comments on this approach.
The public protector states, I must record that the investigation team and I had immense difficulty piecing together the truth as information had to be clawed out of PRASA management. When information was eventually provided, it came in drips and drabs and was incomplete, despite the fact that the means used to obtain information and documents from PRASA included a subpoena issued in terms of Section 7, subsection 4 of the Public Protector Act. Many of the documents and information requested are still outstanding. Until about 3 weeks before issuing the report, PRASA was still being asked for outstanding documents and information on the contracts and some staff appointments. I must say at this point, Chairperson, that at the time when the Public Protector report was being finalized, I had also, my board of control had also been approached to assist in providing information to the Public Protector, and we actually had a meeting, 2 meetings or so in the offices of the Public Protector. I think the first one was on the 26th of June.
2015.
2015, 26 June 2015. And of course, Mr. Montano was very unhappy that I went to meet with the Public Protector with other directors. We did request, and the minutes of our meetings would record that we asked Mr. Montana to comply with the request of the public protector. At that time, we had also found that the subpoenas issued came through the office of the group chief executive, Mr. Montana, but to the extent that they affected members of his management team, they were not given to them. So he wanted to be the sole person who's not only the custodian, but the controller of what goes out and what doesn't go out.
Then may I ask you to please read paragraph 19, Roman 19, on the same page. It's the very next
Same
paragraph.
page. Yeah. Same page where you were reading the next paragraph. Page 21.
But what are we reading there? I don't have anything different from what I read earlier. Maybe paragraph.
I think,
Paragraph.
Mr. Sonny, are
But
you
what I
drawing?
have here is paragraph 18 on page 20. Maybe I must go
We've
to
read paragraph 18.
But-
Can you now read paragraph 19, please?
on which page?
The next page. Well, on yours and mine seem to be the same. Paragraph 19 would be on page 21.
Mine is on
19 is 19 in terms of Roman figures.
Yes,
It starts with, I must also indicate. Is that right, Mr. Sonny?
that is so.
I must also indicate.
Yes.
Yeah, that's the one he would like you to read.
Read that into the record.
I must also indicate that the authenticity of many of the documents submitted by PRASA management as evidence, principally relating to procurement, is doubtful. Many of the memoranda for approval of tenders and related documents submitted by PRASA management were undated, unsigned, and at least in one case, incomplete. Examples in this regard include documents relating to the contracting of Vimsire Security, Arup, and Enlightened Security Services. In some of these cases, had this been an audit, only a disclaimer would be a legitimate audit outcome. Now, Chairperson, I did say that the public protector had expressed concern about the authentication of documents, that they could not authenticate the documents and they were not being assisted by PRASA in a way of authenticating those documents.
Well, you did say a few minutes ago that Mr. Montana sought to control the incoming correspondence and what went out of PRASA to the public protector. And you made the point that to the extent that he needed to have communicated with his management team on some of the matters raised by the public protector or in correspondence, I think you referred to the subpoena. It looks like he did not do so. They were unaware. So I want to ask the question, where the public protector now says the PRASA management was submitting to her office documents whose authenticity was doubtful, and where she says many of the memoranda for approval of tenders and related documents submitted by PRASA management were undated, unsigned, and at least in one case incomplete. Would that mean that although it says PRASA management, in terms of your experience or understanding, are you able to say that actually refers to Mr. Montana because he was controlling correspondence that comes in and that goes out? Or are you not able to say whether that was the position, or whether there were other members of the management team who may have been party to this.
Chairperson,
You don't know.
reiterate my statement that he was controlling information,
Yes.
that he had not availed the subpoenas to the individuals mentioned.
Yes. Yes.
Because the information from the public protector was channeled through the group CEO's office. It was pretty clear to me when I met with the public protector in June 2015 that, well, we became aware for the first time that there were these subpoenas. But when we went back, the individuals mentioned had never heard anything about the subpoena.
Okay, thank you.
Then, well, may I just ask you, Ms. Molefe, you've now read specifically what the public protector has said about the authenticity of documents, the incompleteness of documents, and so on. Are you surprised that that is how the PRASA management, through Mr. Montana, dealt with the public protector's requests?
I am not surprised, Chairperson. Early on in our engagement as the board of directors, I indicated that in 2014, the November meeting, we were advised that there was a probity report which was to give assurance to the board that procurement was done properly. It had not been there. And I subsequently indicated that the board had requested the contracts which had been concluded before it was appointed. Again, this request was not honored. So I would not be surprised. It was a pattern of behavior of the organization, of the group CEO.
Of course, as I understand the position, here the public protector is complaining that PRASA management, and maybe we should read the group CEO, was not cooperating in furnishing information and documents to the public protector. But you also gave evidence either yesterday or the day before yesterday that your board, soon after it had been appointed, sought or asked Mr. Montana to provide it with various contracts that had been concluded in regard to the modernization program, and that these were never provided. He never provided these to you. So is my understanding correct?
That is correct.
Okay.
And earlier you said that it seemed to reflect a pattern. Would that be correct?
That I said so, Chairperson.
Then, if we could carry on with paragraph 69 of your affidavit, Mr. Molefe, you talk about what the public protector found in relation to labor relations at PRASA. What did
I'm sorry, did you move away, Mr. Sonny, from the page that, from our page 21? I don't know where.
Oh, sorry, I'm going now to the affidavit again. Sorry, Mr.
Oh, well,
Mr.
before
Mr.
you
Molefe.
go, you do so, Mr. Molefe, you see the paragraph that comes immediately after the paragraph you read that is now in the public protector's report, page 21. There's the paragraph 19 that you read, starting with, I must also indicate. Can you see that paragraph? Can you see that paragraph?
I do see it.
Yes. The one that comes after that, which is paragraph 20, the public protector says something on which I think you should comment. She says, after unsuccessfully asking the new PRASA board and its chairman to assist, I decided it would be in the public interest to proceed with the report and defer unanswered questions to second report. Now, that may or may not, that unsuccessfully that she uses, may or may not give the reader the impression that your board didn't also cooperate in this regard. But maybe that's not what she means. Are you able to comment on that statement?
Chairperson, reading it, if you not have other facts proving otherwise, yes. It's a conclusion that one could draw.
But you may be able to comment and give context.
But the context is that the board was asked on the 26th of July to assist. The board can only assist through its group chief executive because the board doesn't keep records. And it was clear that the previous board and the chief executive did not cooperate. Even during our time, they did not cooperate. For example, if you, maybe I shouldn't go into the details, but that's what it means. We offered to cooperate, but we could cooperate only to the extent that we can get information.
So therefore, it seems from what you say that it would be fair to say she's correct in saying after unsuccessfully asking the new PRASA board and its chairman to assist, that her attempts to get the board and its chairman to assist, that request was unsuccessful. Those attempts were unsuccessful, even in effect when she had asked the board to assist her. But what you are saying is there was a reason for the board not, and its chairperson not being able to assist. And the reason was that the board did not keep records. It's the management that keeps records, and the group CEO was not assisting the board. Is that right?
That is correct, Chairperson. Yes. I understand that paragraph to mean that even as I had asked the new board to assist, that effort yielded no results. That's how I understand it. And the results are directly linked to the need for cooperation by the group CEO and his management team.
No, I think the meaning you attach to it is fair, is correct. It's just that in the absence of the report saying anything as to the reason why even the board was not able to assist, and against the background of the lack of cooperation dealt with in previous paragraphs in relation to the group CEO, the reader could get the impression that how even Mr. Molefe's board didn't assist here. But you are giving the reason. You say you as the board were committed to cooperating, but you had to ask management to do certain things, and the group CEO did not play his role, the role that you expected him to play.
That is correct, Chairperson.
Okay. Maybe one should ask, what kind of time or period are we talking about when this was happening? Was it at a time when the group CEO had already given his so-called letter of resignation, actually it was during the period which came after the board asked him to stay on for 6 months.
That is correct.
So he was somebody who was on his way out. I think that's one of the points
He
you
was
made.
on his way out, but he was still in office, in charge.
Yes. But could this be one of the reasons why the board decided that his continued presence in the company wasn't serving the purpose that the board wanted? Or not really?
Whilst we would not have specifically said that about the public protector, but
Yes.
we did say that increasingly
Yes.
the board was finding it difficult to get information from the group CEO. In fact, he was even beginning to give excuses for not being available for board committee meetings. So essentially, behaving in a manner that made committees to some extent dysfunctional, because the memoranda that committees consider have to be approved by the group CEO. So that was the problem that we were beginning to experience. That coupled with other unbecoming behavior which played itself out on the public domain. I did refer to kind of statements, regular attacks on the board of directors. It was then clear that we needed to ask him to go. So it's a combination of all of those, Chairperson.
Would I be right in saying, while the purpose for which the board wanted him to continue for 6 months was to, or the primary purpose, maybe I should say, was to assist the board to get his replacement, that would have been on the assumption that he continues to perform the duties of Group CEO in the manner expected of him by the board?
That is correct, Chairperson, except for those conditions which I articulated in my evidence yesterday, relating to further appointments of employees, and awards of contracts, and of course him serving on the boards of subsidiaries.
But basically, it must have been, among other things, on the basis that he would continue to cooperate with the board, because in order for the entity to operate properly, there should be cooperation from the Group CEO with the board.
That was at the heart of the decision of the board to allow him to serve the company for another 6 months, Chairperson.
Thank you.
Sorry, Mr. Chairperson, I perhaps should have dealt with that issue. The problem is I had consulted on that issue, and based on what Mr. Molefe said in evidence, it didn't seem to me to be relevant. But you're absolutely right.
Yes.
Looking at it objectively, that's a matter that should have been pursued, and I apologize.
No, that's fine. It just seems to me that you can only ask a Group CEO to continue for any particular purpose on the basis that he would cooperate with you as the board. If he doesn't cooperate with you, then it doesn't look like there would be much purpose in wanting the board wanting him to continue. So that's why I wanted to get that clarification.
Then, Mr. Molefe, if we go back to your affidavits, that SS6, paragraph 69, regarding the labor practices, or some of the unfair labor practices, what does the public protector say?
The public protector, Chairperson, notes that, or concludes that Mr. Montana suspended employees without following procedure, and that conduct of habitually suspending employees contravened PRASA's disciplinary code and constituted maladministration and improper conduct on the part of the group CEO.
Well, I see that the public protector said there was a conduct on the part of the group CEO of habitually suspending employees, and that might talk to the issue that I raised with you yesterday when I asked whether you recalled what numbers were involved in the suspension and dismissals of employees. You did say many. You couldn't remember the figure. You said many, but if the public protector talks about habitually suspending, it seems to suggest that there was a habit of suspending employees. So it might be consistent with your recollection that it was many.
It is correct, Chairperson, that it is Judge, consistent with the Deputy Judge President, Chief Justice, with what I said in my evidence. I can come this way a little bit and say, in fact, some of these suspensions happened when I was on the board. There was suspension of the then Chief Information Officer, Mr. Chris Mbata, and one of the managers in the legal function of PRASA, Mr. Fani Dingiswayo, and the head of that legal function, Ms. Martha Ngoye. There would have been others that I would immediately not know, but those were the prominent ones who were suspended. And this is a matter we dealt with at the board meeting held in May of 2015, where we demanded that Mr. Montana reverses his decision in the manner in which he had done it, but also recognize that as the group CEO, he has the prerogative to discipline his subordinate. But we insisted that he needed to follow process. Because what he did with some of these individuals, he simply told the security to lock them out, not to allow them to get into the premises of the company. And having locked them out, he then served them with letters of suspension without following any due process. It is then true that, of course, the individuals came back, and I think he did try to suspend them again, but he was the man going out at the time.
Ms. Molefe, the evidence that Ms. Ngoye and Mr. Dingiswayo will lead, and it's not different from what you say, is that in fact Mr. Montana, at the time you're talking about, had dismissed them. They had approached you, you had approached Mr. Montana. He reversed his decision to dismiss them, but he summarily suspended them again, and that suspension lasted until he left. Is that more or less your recollection?
The facts are correct, but I don't know what those witnesses are saying in the affidavit. Counsel, I haven't seen, but I accept that you having seen it, it corroborates what I have said.
Then in paragraph 70 of your affidavit, you say there was a culture, well, the PPP found something about the poor information management. What does she say about that? At paragraph 17.
The public protector also noted that there was a culture of information, well, it should be information mismanagement.
I think she says a culture of poor information.
Or poor information management, or hiding of information that could provide evidence of maladministration. And I concur with the findings of the public protector.
Now, just in brief, the public protector prescribed a number of remedial actions which you briefly referred to in paragraph 71. What were the more important remedial actions that she prescribed?
Fundamentally, the public protector chairperson wanted action to be taken.
So just deal with the conduct of people like Mr. Montana. Did the board act on that?
The board, I should say, chairperson, by the way, if I remember very well, the report of the public protector, when it came out, Mr. Montana had already left.
Yes.
The only way in which the board, well, one of the ways in which the board could then address the concerns of the public protector to the extent that we had initiated disciplinary proceedings. Of course, he then resigned at that point. In respect of the rest of the employees, we secured the assistance, the services of a firm of attorneys, Handlim Kabela, to deal with all labor-related matters arising out of the public protector's report. At the time when I left PRASA, that process was still continuing. And I must say, Chairperson, that we regularly gave the public protector an update report on what we were doing about the remedial actions.
Just for the record, Mr. Molefe, at paragraph 65, you make the point that in 2015, your board took action against Mr. Mtimkulu, but he resigned, just as you've just said. I'm just saying that it is contained in your affidavit.
It is correct, Chairperson.
Right. And in with regard to the National Treasury, the reporting matters to the national, or supporting the National Treasury, did the board participate in that process?
The board did cooperate, Chairperson, but at the time of this report, as I say, the board had already taken steps to deal with issues of corruption. The company Worksmen, a firm of attorney Worksmen's, had already been appointed, and they were busy investigating. In order to avoid duplication in the investigations, I held a meeting with the Minister of Transport, the Director General in that, or Acting Director General in that department, the Chief Procurement Officer of National Treasury, Mr. Kenneth Brown. At that meeting, we agreed that all the investigations would be coordinated under the board of PRASA, and that National Treasury would be informed about what PRASA was doing. Down the line, of course, because there were very many small contracts, approximately 200 of these contracts. We then agreed to disaggregate them, to separate them from those that PRASA had already started investigating, and let National Treasury would deal with them. But the coordination continued in that regard.
Mr. Molefe, let's get to the next major issue that you raise in your affidavit, namely the attempt of former President Jacob Zuma to intervene in regard to the board's acceptance of Mr. Montana's so-called resignation. Will you explain how that came about, please?
Chairperson,
I wonder, I'm sorry, Mr. Molefe, I wonder whether we should use the 5 minutes left before lunch, or whether we should start it after lunch.
Yes, and I take your point, Chairperson.
I'm quite happy that we use the 5 minutes, but it seemed to be the kind of topic that you should rather start and take up to finish without interruption, if possible. Is that fine with everybody?
it is fine with the Chairperson.
Okay, let's take the lunch break. It is 5:02, and then we'll resume at 2 o'clock. We adjourn.